video number 2 now, going through the Equalities Act, so to help you understand your rights under the law. Okay, and this is crucial, by the way, because some people don't seem to understand. Some people might be a bit confused over this, but an impairment does not have to be a diagnosed medical condition for you to qualify. So, let's break it down. In other words, so for example, I could give an example. Many children and adults, for that matter, might not yet have a diagnosis, say of something like autism or dyslexia or dyscalculia or ADHD. They might not yet have a diagnosis, because of very long waiting lists or whatever. And yeah, if they have evidence of long-term impairment, by long-term, by the way, that means longer than 12 months, and it's affecting their day-to-day activities, and they've got medical evidence, they have to provide medical evidence. They might not yet have a diagnosis, but they can provide medical evidence, maybe psychiatrists or doctors or whoever they're seeing, to show that they're impaired in that way. They will be classed as disabled under the Equality Act. So you don't actually need a diagnosis to be considered to be disabled. By a diagnosis, I mean an actual, official psychiatric or other diagnosis to qualify under the Equalities Act. Many people are confused by that, because a lot of people might be under the illusion that you need a diagnosis to qualify under the Equalities Act as disabled, but you actually don't. The Equalities Act is very clear about that, and it covers mental problems as well. So this also includes mental illness. As someone might not necessarily have an actual diagnosis yet for mental illness, maybe they're waiting to see a psychiatrist, they're waiting to see a psychologist, they might not yet have that diagnosis of, say, OCD, anxiety, depression, whatever it is that they actually have, but it hasn't yet been diagnosed. If it's causing them clinically significant impairment, and they can get evidence of that while they're waiting, under the Equalities Act, they're still considered to be disabled. So I really want to clear that up, because it's in black and white, it's very clear, it's very transparent. You don't need a diagnosis to be considered, legally, to be considered disabled under the law. That's very, very important. I really want that to clarify that in people's minds, so that people understand this, because otherwise there'll be people out there, on waiting lists. I mean, I'm lucky I've got my diagnoses, but there are lots of people who don't yet have their diagnoses because of these very long waiting lists, who might be really struggling. You are still covered under the Equalities Act. If you need reasonable adjustments, like, at work, or if you're not in work in other areas, in public, support services, whatever, you are legally covered by the Equalities Act, even if you don't yet have that diagnosis, so you can ask for reasonable adjustments. So yeah, an impairment, this is on the Citizens Advice website, so do go and check it out. An impairment doesn't have to be a diagnosed medical condition for you to qualify. If no diagnosis, however, you will still need medical evidence to show impairment has substantial and long-term adverse effects on ability to do day-to-day activities. So yeah, so you'll still need to have evidence. It's a bit like when you're trying to apply for disability benefits. People can apply for disability benefits even if they don't have a diagnosed condition yet. When I first got DLA, as it was back then, I didn't yet have my autism diagnosis, and I didn't yet have my OCD diagnosis, and it was hard, by the way. We had to go to tribunal. Realistically speaking, it's a lot easier to get these benefits if you have a diagnosis. It's easier. In theory, you can get them without a diagnosis, but in reality, it's a lot easier to get them. You're more likely to get them if you do have that diagnosis. In reality, shouldn't be the way, but that's how the system works. So, there's a bit of a kind of discrepancy between theory and reality, and like I said, we had to go to tribunal. Once I'd got my diagnoses, it was a lot easier. But I did actually get the DLA after the tribunal, which was one, even before I got my OCD and autism diagnosis, just because we did, the evidence was clear, that I was impaired, and that's, yeah, so it's the same under the Equalities Act. You are considered to be disabled if you're impaired, regardless of whether or not you've yet got an actual diagnosis. So I really want to clarify that in people's minds, so that they don't go away thinking that you're only legally covered if you have an actual diagnosis, because that means many people out there won't be able to get their rights met. There are a few conditions, by the way, that are not considered to be disabilities under the Equalities Act. Hay fever, for example, is not considered to be a disability under the Equalities Act. I was actually quite surprised by that, because, lots of people have hay fever and it can be quite mild, but for some people it can actually be very, very severe. So I was a little bit surprised why, surely if someone has hay fever and it's very severe and causing them a lot of problems, and it's been going on for over 12 months and it's really affecting their day-to-day life, I'm surprised actually, and yet other conditions that might not be so impairing, such as someone who needs to wear glasses. Obviously, if they didn't have glasses, they'd be severely disabled, by the way, like they wouldn't be able to see or whatever. But it's being managed, automatically considered disabled. But it's a weird discrepancy. I don't quite understand why hay fever isn't covered if it's severe enough. That's kind of a bit weird, if you ask me. But yeah, hay fever is not considered to be a disability under the Equalities Act. It can still be very disabling, but unfortunately, under law, you are not considered to be disabled if you have hay fever. And then there's a few other things like a tendency to steal or set fire to things. I suppose people with oppositional defiant disorder, that sort of thing, wouldn't be considered to be disabled under it. An addiction to alcohol or a drug addiction isn't automatically a disability under the Equalities Act. So just because someone's got an addiction, they're not automatically considered to be disabled under the Act. But they might be considered to be disabled if they have an impairment caused by the addiction. So if it's significantly affecting their life in a very adverse way, maybe causing a mental illness, really affecting their life, then under the Equalities Act, they will be considered to be disabled. It's just not an automatic qualifier. But again, very few things are automatic qualifiers under a disability under the Equalities Act anyway. The impairment must last for at least a year, so 12 months. That's longer than DSM diagnoses. In DSM diagnoses, it's a 6-month qualifier. You have to have had symptoms for at least 6 months to qualify for certain mental health conditions. But under the Equalities Act, you must, in order to qualify as disabled, it must be at least 12 months. The impairment is still considered long-term if the effects come and go. So, for example, fluctuating or recurring effects. Many mental health conditions will come under that, depression, OCD, things like that. So, someone might improve and they might not have any symptoms or minimal symptoms, maybe they're doing really well. But if there's evidence that this is a lifelong condition and it will likely come back under stress or whatever, they're still considered to be disabled and therefore the Equality Act still applies. You meet your definition you meet your definition of long term if it has a substantial adverse effect when the symptoms occur and it could happen again. You're still covered. Substantial effects could be that it takes you longer with everyday tasks, for example, getting dressed. It's difficult to go out on your own, say due to a phobia, a learning disability, OCD or whatever, like being housebound clearly. You avoid socialising, or socialising causes you great anxiety or difficulty, as is the case for many autistic people. You might need to use a reading aid, say if you have dyslexia or something. Yeah, just a few examples of significant impact. Obviously, the list is not exhaustive, and there are lots of examples of how disability might affect your day-to-day life. The legal test for disability is based on what impact the condition would be if no medication or treatment is given. So someone is legally still considered to be disabled if they're having treatment and their condition has improved and they don't have any symptoms at that point. But if that treatment was stopped and the person's condition would come back, then they would still be considered disabled even if their symptoms have gone away or declined because they're under treatment. So say for example someone with ADHD who takes medication, they might not yet, then they might hardly have any symptoms and they might be much improved, but they're still considered to be disabled because if that medication was stopped, then all their symptoms will come back. So they're still considered to be disabled under the Equalities Act if it would cause them severe impairment if that medication was removed. The legal test doesn't apply to visual impairment though. They are considered disabled if it has a significant impact on their eyesight, even if they're wearing glasses. They're still considered to be disabled under the Act. Okay? The Equality Act, by the way, replaced some earlier legislation. For example, there's been many disability legislation over disability acts over the years, including the 1995 Disability Discrimination Act, which is very similar in many ways in terms of its definition of disability. Under the 1995 Act, you're considered to be disabled if you have a physical or mental impairment which has a substantial and long-term adverse effect on ability to carry out normal day-to-day activities. So really very, very similar. Again, no diagnosis is needed, only that it has a very significant long term. I was considered to be disabled when I was about 9. Obviously, I was disabled before then, but legally, I suppose, considered to be disabled from the age of 9, because that's when I had an educational psychology assessment outlining my difficulties. Although I wasn't diagnosed autistic until I was 21, and I didn't have an official diagnosis yet. The fact is, because there was that evidence of significant long-term impairment, I was still considered to be disabled, and that's why I got into secondary school on a disability placement. But yeah, I just wanted to make that very crystal clear to basically, people are confused about who is legally considered to be disabled. So I really hope that by going through the Equalities Act, you will understand that you are disabled, that you could be considered to be disabled, not necessarily, not automatically, but you could be considered if you have dyslexia, dyscalculia, autism, ADHD, dyspraxia, speech and language impairment, and a whole host of other things. You could be considered to be disabled under the Equalities Act, and you don't need an official diagnosis to be considered to be disabled, as long as you have evidence that it's causing you significant impairment of at least 12 months duration. So, thank you for watching.